Good to go, Holly?
Yes, we are live now.
Okay. Well, good morning, everyone. It's March 25th. This is the Township of Southgate Committee of Adjustment hearing. I will call it order at exactly 9 o'clock. Uh, confirmation of the agenda be resolved that the committee confirm the agenda is presented. May I have a mover and a seconder, please? Brian moves it, seconded by, Barb, thank you. Declaration of pecuniary interest. Are there any? And if not, anytime during the meeting, you can bring it forward. Adoption of minutes. Be resolved that the committee approve the minutes from the February 25th, 2026 Committee of Adjustment meeting as presented. May I have a mover and seconder there, please? Joan? Jim? Thank you very much. Okay, before we have the hearings, we have a report of municipal officers. Director of Development Services, Ken, you have a report. May I have a mover and a second to put this on the floor, please?
Mr.
Barb?
Chair,
Yes?
could we vote on the last motion, please?
Oh, I am so sorry. All in favor for adoption of the minutes? Uh, Seeing any opposed? That is carried. Apologies.
I'll move the next one.
Okay, and you will move. Thank you, Barb. Second for the report. Brian, thank you very much. So Ken, I guess, as they say, the floor is yours.
Thank you, Mr. Chairman, and good morning to you, members of committee. If this item seems a bit familiar, I'm going to take you back to some previous council meetings, especially the one last week where council approved OPA 11, which is alternative measures. Pardon me, I seem to have the mayor's cold as well. So I know who to send the thank you card to. So as as committee will recall, when you wear your council hat, last week you approved OPA 11 to be sent to the county. And as we talked about during the public planning meeting, there was an initial draft of that OPA that included language from the existing Ontario Regulation 200/96 related to reducing the minor variance distance. And as we went through legal review, we ended up taking that out because our legal counsel said it's not really related to alternative measures. You can, committee can enact this and council can't. So, just take it out and ask committee to consider it. And that's why we're here. So given that council gave direction to approve OPA 11, we wanted to bring this back to committee for some direction. And I'm just going to share my screen and just explain what this amendment in the report would do. Just give me 1 second. I'm not used to Zoom screen sharing here. Let's try this again. Here we go. And then share. So you should be able to see the e-laws version of the OREG that I mentioned, and highlighted there is section 6. So what you're seeing is direction given to municipalities on how to give notice for minor variances, because as you'll recall, when you had your council hat on last week, I noted that minor variances are not included in alternative measures. And part of the reason I suspect that is the case is this additional provision in the OREG that allows for a reduced distance. The reduced notification distance still would be paired with posting of a sign on the site, and it is restricted only to parcels that are on municipal services and that are zoned for low density residential. So single detached, semi-detached duplex housing. So any zone that would have, say, townhousing would not be applicable. This wouldn't apply to commercial, and it wouldn't apply to industrial. And part of the main thinking behind that is that when you have minor variances related to low density uses, you're not usually talking about issues where the impact of those variances would potentially impact parcels greatly great distances away from the subject site. So as noted in the OREG, this is a decision that Committee of Adjustment will need to make. And so we're asking for direction as to whether or not you wish to use this or not. And just know that if committee chooses not to adopt, pardon me, the resolution that we've recommended to use this section, then the status quo would remain, which would be a notification area or range of 60 meters. And notwithstanding any of that, we would still continue to post a sign. I will stop sharing and I'm happy to take any questions.
Well, thank you, Ken. Are there any questions from committee? Barb, go ahead.
Thank you, and good morning, everyone. Thank you, Mr. Chair. Ken, so you're proposing that on everything other than commercial and townhouses, that the notification range would be 30 meters instead of 60 meters?
So it would be restricted to any parcel that is exclusively zoned for singles, single detached, semi-detached, and duplex. If it has any, so if it happened to have townhousing or multi, then it's not included, and obviously commercial, industrial, and institutional wouldn't fall into that either,
And
or agriculture.
And so I guess my question is, one of my questions is why is this not a council decision? Because aren't we changing the zoning bylaw?
Through you, Mr. Chairman, it's not a council decision specifically because of the wording within the provincial OREG. It says the Committee of Adjustment may direct that the area of notification set out be reduced. So that's not something that council can do. And no, it's not actually a change to the zoning bylaw, because the notice provisions and the distances within the notice provisions are set out through the Planning Act and this OREG.
Okay. If I may, Mr. Chair.
Go ahead.
So there would be no public meeting with regard to this. This is it. This is the public meeting and we're going to approve it today.
Through you, Mr. Chairman, it is something that the committee can choose to do or not do.
Okay.
It doesn't change the fact that if you were to approve the reduced distance, all that would happen is that a couple of properties would likely not receive individual mailed notices. However, because this is related to subsection 2, which is the mailed notice and a sign, there would still be a sign posted on the site as well. So what would likely happen is if I was at 45 meters, if you chose to enact this, I would not receive a mailed notice, but I would be able to see the sign posted on the site. So from my perspective, and in my opinion, it still achieves, it reduces the number of mailouts that we have to do, but the sign is still there as well for any surrounding property owners.
No, understood. Thank you. One more, sorry, Mr. Chair.
No worries.
So if this were approved today, it goes into effect immediately, but is it possible that we at least advertise this so that people are aware? Because, you can see that there's very few people in the audience virtually. I don't know how many people actually follow along Committee of Adjustment unless there's a specific file that they are interested in, that they've seen a posting. And this, not that I expect that there'd be any issue, because obviously the sign is being posted and it makes sense in an urban center where, 30 meters from a boundary, it probably in the new developments extends, probably 2 properties at least. So I don't have necessarily an issue with the change other than the fact that we haven't really communicated this in a more like pushed it out there as opposed to here we are going to approve it today. Thank you.
Thank you, Barb. Joan, go ahead.
Good morning, Mr. Chair. Good morning, Ken. You said it is, as far as what you're saying, it is either or either. It is embedded in the document in number 6. It doesn't change the fact whether we approve it or not approve it because it's there. So I'm not too sure if we have a choice or where does this lead us? A little bit more clarification or explanation.
Sure. And through you, Mr. Chairman, good morning, Councillor John. So the fact is that Section 6 within the OREG allows the committee to make a choice. So you're not obligated to approve this. You could say no and then revisit it later as well. So all that's before you is a choice of whether you wish to have the status quo for minor variances or whether you want to use this provision and reduce the distance. And I'll just clarify that the only reason we're bringing this to committee is simply to finish off the work that we were doing with alternative measures, because our legal counsel pointed out that we couldn't keep it within the OPA that was going to council because it specifically is a committee decision. So that's why we've brought it back to you, just to sort of close the loop on all of that work and be able to get a sense from committee of what you wish to do. And then we would use that through the next notice process, because I think we've already done the notices for the upcoming meeting in April. So regardless of what avenue you choose, then that's what we will use for the meeting in May.
Okay, thank you, Ken. Anyone else? Any questions?
Yeah.
Are you done, John? Okay. Anything from you, Jim? No? Okay. Ken, on page 2 of the report in the discussions, it says, I'm okay with this. There is some things I think for the public we should do. Anyway, it says there is no ability for staff not to grant or consider, and then it goes on, where these variances are as of right, notice is not required to adjacent residents and simply issued as per provincial legislation. So even if we do 30 meters, we're still showing the public that there is something going on. Is that the intent? Like, could you explain the difference between as of right and anything else? Because Barb had a good point about even being 30 meters and the sign being posted. One question that comes from that, those people, especially in the density of the new subdivisions, those 3 or 4 houses or 5 houses down, which would have been in the 60, can they still put their opinions in?
So through you, Mr. Chair, I'll try to answer your questions in order. So
Yeah, thank you.
as committee may recall, when you had your council hat on, we, myself and Bill provided you an update on some of the Planning Act changes that were coming late last year. One of those was as of right variances, and that was approved by the province and implemented through an OREG. So what that means is that if you are applying for a minor variance to a setback under very exclusive circumstances, typically low density housing is what I recall. I don't have that section open. Then we have no choice but to grant it, because the OREG is very specific in how the province implemented as of right variances. And so that doesn't require us to give any notice. It's simply issued through the building permit. Planning would confirm as part of the legislative review that the 10% or less variance would apply, and that would be it. What I think the deputy mayor was speaking to was is the fact that regardless of the outcome the option that you choose, whether you stay status quo or you use this additional provision, there is a sign that has to accompany the individual notices. So all that would happen is the number of individual notices would reduce because that distance that would of properties that are captured would shrink. But then there's also a notice that's placed on the site. So anyone passing by who saw the sign would be, you know, if they wanted to submit a comment, they could. And then as part of your deliberations on the matter, you'd have to weigh, you know, the opinions of someone that might live right next door versus someone who might live a significant distance away.
Okay, thank you. Brian, do you have any comments, questions? No? Okay, so Ken, you want direction from the committee to go ahead with this?
So, Mr. Chair, our recommendation is that you enact, that you use the provision. So if that is committee's desire, then you would just simply approve the resolutions as proposed. If you don't wish to do that, then I think I'd have to get some direction from Holly, but I think you would just approve the first resolution only, which would be to receive the report for information, and then there would be no further direction given to staff, which would keep us at status quo.
Okay, I guess the question to the committee members, do you want to keep the status quo or would you like to move ahead with this? Because as far as I'm concerned, if there's a sign up and people who are living 6 houses down, 7 houses down outside of the 60 meters, which is standard, then the public still has that option to weigh in on it. So thoughts there? Do you want to move ahead or stay status? I don't know, do we just copy the resolution or do you have one written up there, Holly? Go ahead.
Thank you, Mr. Chair. So yeah, it would be the resolution that is presented. So it's that the report is received for information and the council directs staff to utilize the notification distance for minor variance presented or provided in OREG 296, section 3.6 going forward.
Okay, great. Thank you. So
That's how it
and-
stands. If for any reason that is not what the committee is wishing to do, then we would need an amendment. But that is the motion that's on the floor at the moment.
okay. Just looking it up here. So is everybody okay with that resolution as it stands? Barb, go ahead.
Thank you. I get why we're doing this. It doesn't, I mean, 60 meters, 30 meters,
120.
it's just another reduction in our residents' voices in our planning. The province continues to strip away, you know, the people's ability to have a say. That is where I struggle with it. I understand it makes sense though.
Yeah, Barb, Brian, go ahead.
Well, I won't argue with the deputy mayor on the broader direction of where this government's going, the provincial government's going, but in the strict sense of the topic, we're not stripping anybody's ability to comment on a minor variance or any other item for that matter, but it just simply reduces the distance that we must give formal notice to. Those neighbors, 60 meters, 100 meters, 2 kilometers, 10 kilometers, they can still comment on a variance if they choose so.
Yeah, that's true. And I tend to agree with both of you about the eroding of certain things for, shall I say, the common person. But yeah, this is only applying to urban areas anyway, and none of this applies to outside. And efficiencies, you know, less paperwork going out and what have you, and the fact that, you know, as I said before, and I think it's been mentioned by others, that the density is so high. 30 meters, that could be all around north, south, east, west. That's probably 15 houses anyway. So I will put forth, let's go with this, the resolution that's there, and need a mover and seconder, I guess. Oh, Holly, you're telling me I'm doing something wrong, eh?
We have a mover and seconder.
Oh, yes,
already.
sorry about that.
Member Dobreen moved and member Milne seconded.
Oh, okay. So Barb, go ahead again.
Or, sorry, just one quick question, for clarity. This only applies to single-family dwellings, semi-detached, and duplexes. All others, commercial, industrial, multi-residential, would remain at 60 meters?
Correct.
Okay, thank you.
For minor variances, yes.
Okay, well, be it resolved, the staff report PL 2026-016 be received for information, and that committee directs staff to utilize the notification distance for minor variances provided in OReg 200/96, section 3, bracket 6 going forward. All in favor? That looks like it was carried. Thank you, everyone. And now I'll get right back in. I'll just move my other screen over. Thank you for that, Ken. Let's see. Okay. Now we'll go into the hearing part. My name is Martin Shipston. I'm the chairperson of the Committee of Adjustment, and I call the meeting to order at, well, that's all been done. The committee members include members of council. However, we sit at this table as a committee of adjustment and not as members of council. Our jurisdiction lies solely with matters of consents and minor variance applications. The secretary of this committee is Holly Melnick. This is a hearing to consider applications for minor variances and consents within the Township of Southgate and is held under the provisions of the Planning Act 1990. This hearing will be in accordance with the Provincial Planning Act, the Municipal Act, and the Township of Southgate OP official plan. Confirmation of agenda. We've gone through that. So this hearing is for, there is 2 on the docket. This one is for A1225. And before I go into that, I'll ask that anyone speaking about an application to state their full name and address for the record. Excuse me. Please keep all remarks relevant to the consent or minor variance application before us, as the Committee of Adjustment has no jurisdiction on any other matters. Any material submitted to the committee for viewing will remain the property of the Committee of Adjustment and will be available for public viewing in the application file and may be placed online. Please direct all remarks to myself. This will enable the hearing to be conducted in an organized manner. So A12-25, Kathleen Brody. The purpose of the application is to obtain approvals for an existing barn built years ago. The barn would be used as part of an ongoing agricultural operation. A small addition to the barn is proposed. The interior side yard setback proposed for the existing barn and addition is plus or minus 3 meters, although the exact distance to the east lot line has not been verified by survey. The required interior side yard is 15 meters minimum, and the effect of this application is to allow a variance of at least 12 meters, so an existing barn built more than 6 years ago can remain, and a small addition to the barn built with an estimated plus or minus 3 meter interior side yard to the unsurveyed east lot boundary. Location of the subject land is legally 084457 Southgate Road 8, concession 8, part lot 21 RP 17R 2008 PT OF, part 2, geographic township of Egremont, Township of Southgate. And the civic address is 084457 Southgate Road 8. Holly, was there a request for deferral or withdrawal of the application?
Thank you, Chair Shipston. There was none received.
Okay, thank you. May I please have clarification that sign was posted?
Thank you. I can confirm that the sign was posted and notice was given in accordance with the Planning Act.
Okay, thank you, Holly. I will now ask for Victoria. Yeah, there you are. Any comments received, and present your report to the members, please.
Wonderful. Thank you. Good morning, everybody. So as the chair outlined, the applicant requests a minor variance. They'd like to reduce the required 15-meter minimum side yard for an existing livestock barn to about 3 meters. It was built without a permit over 6 years ago beside an existing barn. In one of staff's reports, our attachment, the county GIS mapping for the lot overlay shows the barn partially located on the abutting lot to the east. So the neighboring landowner and the applicant did speak. They did state that they had no concern with the building location. It's been there for quite a while, and they estimated a side yard setback of about 3 meters. So originally they proposed a 30 square meter chicken coop addition or to the livestock barn, and a building permit is recommended as a condition of the minor variance. It was originally a complaint that came in, and then an OTC, or an order to comply, was issued. An Ontario Land Surveyor certificate is recommended to verify the existing building, or the 30 square meter addition does not straddle the lot line. Staff also suggests the 4 tests for a minor variance under the township official plan can be met, subject to the conditions as they've been outlined. A livestock barn was constructed on site without appropriate approvals, so they came forward for a Planning Act application to address it. The location is not in compliance with the zoning bylaw as it sits right now. The proposed minor variance would address the required 15-meter side yard for an existing livestock barn built about 6 years ago, between 2006 and 2020. With a 3-meter side yard. The exact distance as it's been outlined from the east lot line hasn't been verified by survey, but was discussed with the abutting landowner. The applicant also submitted a nutrient management plan in support of the subject application. They have about 13 chickens in that building, and a 30 square meter, as outlined, is proposed to the existing barn. Just to provide some context, it's a bit of an odd looking lot. It's triangular. It has about 250 meters frontage along Southgate Road 8, over 210 meters depth, and is about 2 hectares in lot area. Contains an existing farmhouse and 2 livestock barns. The farmhouse is about 135 square meters. There's a 143 square meter livestock barn, and then the 170 square meter chicken barn as well. And the chicken barn itself is the one that's looking for a minor variance. It has a setback of about 3 meters, as they've noted on their site plan. The irregularly shaped lot was also created in 1991, according to County Land Division decision, and consists largely of heavily treed areas and the South Saugeen River along the northern lot line as well. Surrounding lands are largely agricultural properties, and then some smaller sized rural lots located to the north of the site. And you can see that on attachment 2. So some comments received for this are found on page 3 and 4 of staff's report. Township Public Works advised that safe access can be provided and had no further concerns. The Saugeen Valley Conservation Authority also stated that based on the submitted plans and staff's observations on site, the chicken coop was determined to be located outside of the ravine slope erosion hazard. They also confirmed that the completed works conform to the SVCA policy and have no further concerns. The unauthorized works have been approved after the fact by SVCA staff as well. And some comments were received after the writing of this report and included Historic Saugeen Métis and Grey County, both of which had no concerns with the proposed. So just to outline the 4 tests for a minor variance, it maintains the general intent and purpose of the official plan, as agriculture uses are permitted in the designation, and the existing livestock barn does not encroach into the hazard designation. It maintains the general intent and purpose of the zoning bylaw, as the livestock barn and the proposed expansion will be verified not to encroach on the abutting lands, and remaining regulations in section 6.2 for an existing agriculture use will be met as well. It's minor in that the proposed variance would not impact abutting lands based on discussion between the owners, and the livestock barn would not impact any sight lines entering or exiting the driveway as well to the south, or the existing use on site. And it is desirable for the appropriate development of the subject lands as well, that the existing livestock barn is entirely within the A1 zoned area on site. It won't impact any other existing land use in support of the agriculture, and nutrient management plan has been provided to confirm that manure for the livestock on the property can be effectively managed. So at this time, staff are recommending that an Ontario Land Surveyor verify the existing livestock barn and make sure it's located within the subject lands, and that the expansion does not straddle the lot line. As well, a building permit must be obtained to confirm adherence to the building code, to the chief building official satisfaction as well. Happy to take any questions.
Sorry about that. I was having trouble with my mute button. Are there any questions, Victoria? Brian, go ahead.
Thank you, Mr. Chair. Victoria, the proposed condition of an Ontario land surveyor, I'm not certain that that's entirely required, in my opinion, because it's going to be costly for the landowner, and it probably wouldn't change anything other than the neighbor might think that the coop is sitting on their property and they might need some eggs for breakfast someday. But I just, is it entirely necessary to have the surveyors come in and check that? I guess that's my question.
Through you, that was something that we had discussed, and I know monetarily that's a lot as well. That's why we went either a survey or a certificate, where the certificate is a lot less costly. Still costs quite a bit, but it's just to confirm the lot line boundary and that chicken barn wouldn't be over the east lot line boundary into the neighboring lot. So it's up to committee if they would like to take that out as a condition. It was just a recommendation, either the survey or a certificate. But as well, it's kind of up to the CBO if you'd be comfortable issuing a permit for the expansion just on the variance and not require the certificate or the survey as well. So that's kind of staff's recommendation, either a survey or certificate, or if the CBO would just be comfortable going off of the variance, it would be what he would be comfortable with ultimately to issue a building permit.
Okay, thank you.
Okay. Any other comments? Barb, go ahead.
Thank you, and through you, I don't disagree with Brian, but obviously there was a complaint. Otherwise, we wouldn't even know about the chicken barn. Is it currently a chicken barn? Because it just says livestock. And then there's a barn. So I'm not sure which, so the addition is the 30-meter addition is going on the one that abuts the property line.
That's correct. Yeah, it is through you. It is a chicken barn. And it was not, it wasn't the east abutting owner that had a concern with the chicken barn.
That it doesn't matter who it was. I wasn't going to ask, but do we have anything in writing from the abutting landowner that they are satisfied and have no problem with that barn encroaching on their property? And my second to Brian's comment is a certificate might be in order to ensure that the addition doesn't encroach further onto the neighbor's property. If it's unlikely that the property is ever going to change hands, but property lines create issues down the road, and we are approving something that could come back to a future committee of adjustment in a couple of decades, but won't be my problem. Why does it have, so it just says 10 or 12 petting chickens, and they already have a barn, like a chicken coop. I'm like the nutrient management plan can be managed for that facility. How many more chickens? I think we're pardon what I'm going to say is I think we're putting the chicken before the egg, and perhaps the certificate and a written confirmation from the neighboring landowner that they're okay with it as it exists, provided the future expansion doesn't encroach further.
Okay, thanks, Barb. Anyone else? Joan, Jim?
Through you, there is the applicant on the line. If she would like to clarify further, she threw something in the chat there. I guess at this time she's not proposing an addition any longer. It was just to bring the chicken barn into compliance.
Okay. Well, I see Ken's hand is up. Ken?
Yes, thank you, Mr. Chairman. Just to add some clarity to the deputy mayor's question and also Mayor Milne's question. One of the reasons why we wanted to confirm where this barn is located, it's not just, as Victoria says, what the CBO is comfortable with, but nothing in the Planning Act or the building code would allow the CBO to technically issue a permit onto someone else's property unless they are adjoined into the application. So if this is a situation where the barn is actually still on the subject landowner's property, but just too close, that's good. What the surveyor's certificate would prove is if that is the case, if it's over the property line, then I don't believe that the CBO would even be able to issue a building permit because it's technically over the property line, and that would be confirmed through the certificate, and then it would come into an issue of it would have to be adjusted to at least end on the common boundary line or at the property line. So there might have to be modifications made, but we won't know that until we have confirmation through a certificate or a survey.
Okay, thank you, Ken. Okay, Victoria, you said there was in the chat, Kathleen, if I may call you Kathleen, did you want to speak?
Sorry, I was just trying to figure out how to unmute there. I'm not sure where the idea of further additions being built has come from. Like, I can barely afford to get through all these application fees, much less add another addition anywhere on the property. And as well, just to address the one question about where the complaint came from, it came from Toronto, from an ex-partner who has been facing criminal charges in connection to me. So this is something that he sat around at home and thought about and decided to pursue. So that's where the complaint came from, not from any neighbors or anything like that. But yeah, I'm happy to answer any questions you guys have, as I know it sounds very complicated and strange. I had hired a contractor to build this structure, naive at the time, not understanding all the different things that needed to go into it, including a permit. He built it based off of a fence that has existed between the two properties since the 70s, is what I've been told. So yeah, I feel like a bit of an idiot, but I didn't know about all this kind of stuff, and now I am paying the price for it. But if there is any way that some form of this survey or certificate cannot happen. I mean, I got a quote from Wilson Ford, and it ranges between $2,500 and $4,000. So the certificate is still very, very, very expensive. But I also am aware that, like, I am at fault here, even though I didn't know I was at fault at the time. I'm just looking for solutions, and I'm just trying to do everything I can to get through this and not lose my chicken barn. That's the thing. I don't know what the end result is of this type of thing, if it's going to come down or what. But anyways, that's it.
Okay, Brian, go ahead, then John.
Thank you, Mr. Chair. So further to my earlier comment, I'm wondering, I'm not sure what the wording would need to say in the motion, but could we not prevail on the building official to determine whether they're in fact comfortable issuing a building permit without the survey? I mean, if it typically fences between farms are plus or minus, right? I mean, there's a lot of wiggle room there, I suspect. And I would guess that the fence is close to being on the line, if not on the line. But if we were in town, this would be a lot more important, I think. But you're out in the rural areas, a foot or two here or there. I'm not a lawyer, but for sure. And you get into court, a foot does matter. But I'm reluctant to put that at expense onto the landowner for really no reason. So anyway, thank you.
Good, John, and then Barb.
Thank you, Mr. Chair. Is it possible for us to get some kind of confirmation from the neighbor about they not having any problems with it, or if they think it's on their property? Because I read everything and I didn't see anything from the neighbor, as Miss Kathleen just confirmed that it wasn't the neighbor, whatever. So if we could get some confirmation or something in writing also from the neighbor. Thank you.
Okay, Barb? And Ken?
I'll defer to Ken, Mr. Chair, just in case he has a response.
Okay, thank you. Ken, go ahead.
Thank you, Mr. Chairman. I have the township CBO here in my office. So I've just asked him the question, and the issue here is that he isn't a surveyor. So he has no ability to go out on site and say with any definitive certainty that this is the property line and therefore the building is X distance from it. So I think we would still need something from an OLS. If committee is concerned about the cost, then as I understand it, go with the, not the survey, but the certificate. The CBO is nodding that that should be sufficient, but whether the issue comes up here or whether it comes up at the building permit stage, it is still going to be a live issue unless it's dealt with.
Agreed. Thank you, Ken. Anyone else?
I'm next.
Oh, yes, sorry, Barb, sorry.
That's
Go
okay.
ahead.
That's okay. I just, I think, is Bill clapping or wanting to speak?
Sorry, I was supposed to be putting my hand up. I don't want to
I-
interrupt Carlos, though.
No, I couldn't see you, Bill, because I just had,
Sorry.
oh, there you are. Good to see you, sir.
Hi. Sorry, I'm very sympathetic to the staff and actually the applicant as well. Because what you're dealing with is a civil matter between abutting landowners and also perhaps ex-partners. So you're in an awkward spot. What I wondered is if the committee did have a statement from the abutting owner that they are satisfied that that is not on their property for the existing building, and then if there is ever an addition, they would need to get a certificate from an OLS at least. But since the addition is off the table now, you're just dealing with an existing building. And I think it's a good idea to get the building inspector in there and get a permit and have that taken care of. The worst case is that an abutting owner comes in and says, that's on my property, move it. But if the committee did the due diligence and had the current owner give that statement, then I think that might help resolve it. You're just trying to solve something that kind of happened, and it's really a civil matter primarily. But I think if you had the OLS before they expanded, then I think that's wise. And maybe the CBO could tolerate, since the building's already there, could tolerate just a statement from the owner. That's just a suggestion.
Okay. Thank you, Bill. Barb?
Thank you. And that's kind of where I was going now. I mean, we understood that the proposed was to put an addition on. That's off the table, so that changes the resolution. I wonder if deferring this until such time to give Miss Kathleen, an opportunity to check with the neighboring landowner, they may have a survey and confirm, I mean, the CBO cannot issue a building permit for a building that encroaches on someone else's property, like is on someone else's property. It may just be, like Brian said, plus or minus. Would deferring this to allow a little bit of time for that to happen, because we all appreciate that we don't want the chicken barn to have to come down. There's no addition now, which kind of changes the trajectory of it. So, and that would give some time rather than approving something that can't be approved.
Okay, thank you. Yeah, I think in the report it said this was built without a permit 6-7 years ago. So right from there, when it comes out in the open, especially if there was a complaint from another person, that's when everything starts piling in on itself. And in one ways, no pun intended, I'm sitting on the fence here. I don't necessarily think the certificate, it is an extra expense, but because of everything that's going on, just for the liability in the future, I think a certificate would be good. And I think a statement from the other landowner would be good. And that's just my comments. But Brian, did you have your hand up? Go ahead, man.
Yeah, I was just going to ask Ken if he's sitting there looking at the CBO. Would the CBO be, is he able to use the neighbor's statement in that respect? Or is that not on?
So through you, Mr. Chair, no, he would not be able to use that. The other thing I'd add is that the neighbor survey may not show the actual location of a building on an adjacent property because the OLS, the Ontario Land Surveyor, when they do a survey, is duty bound to show everything within the boundaries of said parcel, not necessarily the neighbors. Some do, and it might, but my gut feeling is chances are it wouldn't.
Right. Okay. So essentially we're stuck. We need the survey or the survey or the certificate. So I guess we'll have.
Chair, I would have to agree with the mayor. Like you can take the condition off of here. I wouldn't recommend that. It's simply going to come up again at building permit because the CBO can't issue a permit that's going to put a building onto someone else's property that's not a part of the application.
Right. Okay. I'm done. Thank you.
Okay, any other comments? Seeing none, are there any? Oh,
Sorry.
Barb, go ahead.
So because I'm suggesting that we defer pending more information, if the OLS certificate shows that the existing structure is on the property line or over, then the CBO still can't issue a permit.
Through you, that's my understanding. That's correct.
Very good. Okay.
Go ahead. Thank you. Sorry.
No, did you have anything else, Barb? No? Okay. Well, we'll move on. We already had a chat with the applicant or Kathleen. Any in attendance that would like to speak in opposition? I don't see anybody. Give it a second. I don't hear anybody. I will again ask the committee members if there's a requirement for further discussion, review these conditions as required, if not already mentioned. So, Barb would like to defer this. Are you moving that, obviously, Barb? Is there a seconder for that? Joan is seconding it. Brian?
So now that we know that we can't or the CBO can't use a statement from the neighbor, it's got to be either a survey or certificate. What's the purpose to defer? I know we're not holding anything up really because the building's already there, but what's the purpose? I'm not clear on that.
Rebuttal?
Of deferring.
Of deferring, yeah. Rebuttal there, Joan, Barb?
My intent was to give the property owner a little bit of time to see if the neighboring property owner had a survey, as opposed to requiring them. I guess they could, if they did, they could produce that instead of incurring the expense of getting their own certificate. I'm not sure of how all that works. If deferral isn't, like, I'll defer to the planner as to whether or not deferral is necessary, but then we would move an amendment to change the language of the recommendation because the last clause isn't required for a 30 square meter addition. They're not planning an addition. They're the second last clause has to be removed, the 30 square meter. I'm just trying to provide the applicant a little bit of time to find a less expensive route.
True. Yep, go ahead, Brian.
Well, I was going to say if the budding landowner has a survey, then the surveyor themselves, that it would turn up in their search. They would know that. I'm surprised they wouldn't. If there is a survey, when Miss Kathleen inquired, they probably would have already known that, and they would say to her, "There's a survey already existing." But anyway, if the committee thinks a deferral is helpful, I won't oppose it, but I don't really see the point in it.
Yeah. Ken, you have your hand up? And I think, Bill, you had yours too, didn't you? Ken, go ahead.
Thank you, Mr. Chairman. Maybe I'll start, and then if Bill wants to jump in, he can follow. From my perspective, I don't see the value in a deferral. What I would say in terms of the condition is that we don't have any specific language as to what survey. So if the neighbor wanted to try to get the neighbor's survey, that too could potentially fulfill the condition. The only thing I would be concerned with is that the neighbor's survey may not, likely won't show the building's location. It will just show everything on the neighbor's property. And what planning and the CBO have to be satisfied with is that this building is staying on the neighbor's property. And that's the key here. I would say, though, that you could amend the last resolution to just say that a building permit be obtained for the existing barn, subject to the township CBO being satisfied that the building code is achieved.
Bill, you had a comment, then Holly? Go ahead.
I'm just sorry. Just along the lines of what Ken was saying. I think for the applicant's purposes, having a decision of the committee approving it with conditions, I think shows her some intent of where the town is on this. And so she has time to fulfill those conditions. With a variance, there's no limit. So it's as long as she needs to verify the location of that lot line. So in a year, she verifies it, gets that survey done, and gets the building permit from the CBO then. At least she has the decision in hand and knows that any complaint is being dealt with in this fashion, not through having the building come down.
Yeah.
So I don't think there's an issue giving her an approval if that's the committee's thoughts. And I think it would actually help her because she would have peace of mind that committee has approved it. There's a condition to be met and she can take her time meeting that condition. I don't know that there's a life safety issue that has been identified here that's going to fall on someone or anything like that. So I think typically the CBO would have patience in a case like this, given that it's been there for 6 years already. So I think it would be helpful for the applicant to have a decision given her circumstances, but I don't mean to speak for anyone. It just, from the sounds of it, that's all.
Okay. Thank you, Bill. Holly, go ahead.
I guess actually I'll let Deputy Mayor Dobreen go first. Sorry,
Okay.
Member Dobreen.
Barb, go ahead.
Hi, thank you. And I will withdraw my recommendation to defer, having reread the recommendation and can see a way to amend it, which I think Holly's ready to propose removing that expansion language. So if my seconder is also willing, I would remove the deferral from the table.
Okay. You're good with that, Joan?
Yes, I am good with that because I was just in agreement because I've read everything and it didn't say that the building was on the neighbor's property. It's just that we have to prove that it's not. So yes, I'm good with that.
Okay. Yeah, and that last requirement, a building permit be obtained for the existing barn, that should be done anyway because it was built without one 6 years ago. And that's where all this problem has started from. It could have been built farther back So as I said before, things have compounded on each other. I think the certificate should be that is for housekeeping 5, 10 years down the road, not only for the property owner, but for the township. We have seen where things have not been done right 20 years ago, and they come back to literally bite us, I guess. So with that being said, that was just my comments. Holly, could you please show or read out what you are planning?
Absolutely. I just am having some tech problems, so if you could just give me one quick second.
No problem.
Mr. Chair, while Holly's doing that, I would just suggest that if in fact the neighbor had a survey, if the barn encroached onto that property, the survey would show that.
Mm-hmm.
Okay, it looks like I am not going to be able to share my screen, but I can read it.
If you
that's to the
can read
satisfaction of
what
the
you have,
committee.
Holly, that would be apropos, I think.
Yep, so that staff report PL 2026-014 regarding minor variance file A1225 be received for information that the committee consider approval of minor variance to reduce the required side yard of 15 meters under section 6.2E from the east lot line where the existing barn has a side yard of plus or minus 3 meters, and all other setbacks in the A1 zone and other provisions of the township zoning bylaw are met. That an Ontario land survey verify the livestock barn does not straddle the east lot line, and that a building permit be obtained for the existing barn subject to approval of the township CBO and adherence to the OBC.
Okay.
Through you.
Brian's okay. Brian's okay with that. Barb's okay with that. Well, may I have, there's been a lot of discussion. There is another file. So may I have a mover?
Sorry, Mr. Chair, I think
Yes.
Victoria wanted to chime in. She had her hand up.
Oh, I am sorry.
That's okay, no worries. Sorry, I was just going to suggest an edit, a survey or certificate, if that's
Yeah,
helpful.
good point. Good point, Victoria. Holly, if you could do that, that would be
I
good.
will add that into the clause. We have a mover and seconder for the amendment, so we just need a vote on that, and then the main motion as amended.
Okay. All in favor? That is carried. And a mover and a seconder for the other part that Holly mentioned? No?
It's just a motion as amended. You already have a mover and
Oh, okay.
for the
Very good then. So I will be it resolved that staff report on all that. The decision of the Committee of Adjustment, excuse me, is to grant the application. So Holly, I have done something wrong again and we have my hand up.
Just need a vote on that. We have a mover and seconder, but
Oh,
no
okay.
vote was
All in
called.
favor? That looks like it's carried. Any opposed? No, it's carried. Sorry for the confusion there, people. I was getting two papers mixed up and there we go. So we have granted that. We'll move on. And this is next file, B1225 bracket C226 RHP Farms Limited. The purpose of the consent application is to sever the subject lands to create a lot containing a surplus farm dwelling and garage. The severed lot would have approximately plus or minus 55 meters frontage, Grey Road 9, plus or minus 156 meters depth, and plus or minus 0.9 hectares lot area. The retained lot would have plus or minus 344 meters frontage on Grey Road 9, plus or minus 1,017 meters depth, and plus or minus 40 hectares lot area. Rezoning file C226 is submitted to address compliance with permitted use or site regulations related to the proposed consent. The effect of consent application B1225 is to create a plus or minus 0.9 hectare surplus farm lot containing a plus or minus 103 square meter home with a plus or minus 225 square meter accessory building. The plus or minus 40 hectare retained lot will be used for agricultural and natural heritage, both with access to Grey Road 9. Location of the subject land is legally concession 12, lot 26, geographic township Proton, Township of Southgate, and the civic address is 186142 Gray Road 9. Holly, clarification of any deferral or withdrawal of the application.
Thank you through the chair. There has been none received.
Thank you. Same, may I have clarification that the sign was posted?
Thank you through the chair. I can confirm the sign was posted and notice was given in accordance with the Planning Act.
Thank you. Victoria, you have the floor.
Thank you very much. So again, it's a surplus farm dwelling severance, 186142 along Gray Road 9. They're creating a lot for the existing farmhouse in the garage, about 55 meters frontage along Gray Road 9, 56 meters depth, and about 0.9 hectares lot area. A planning justification report was also submitted in support of the application. They stated that the proposed 40 plus hectare retained parcel will continue to be farmed as well. As mentioned, there's also a rezoning file that's headed to public planning this afternoon to prohibit future residential use on the retained lot and address any site regulations such as area or frontage for the surplus farm lot as well. So some context, it's a flat to gently rolling topography, some treat areas along the southern portion of the lot. There's also a drainage system along the southern portion of the property and continues north. The parcel itself has about 410 meters frontage on the south side of Gray Road 9, over 1,000 meters depth, and about 4.96 hectares lot area. There's some existing buildings too, consist of a 103 square meter single detached dwelling, 225 square meter detached garage, a setback of about 83 meters from the front lot line along Gray Road 9 that can be shown on or seen on attachment 1. And surrounded by some similarly sized 40 hectare farm parcels. They also contain some on-farm diversified uses as well. And then Hopeville's located over 5 kilometers to the west. Comments are on page 3 of staff's report as well. Township Public Works stated that safe access can be provided, but entrance requirements are under Grey County jurisdiction. Some comments were received after the writing of this report as well, included Grey County. So county transportation staff stated that as a condition of provisional consent, the owner shall convey a 2-meter road widening to the county along the frontage of both the retained and separate lot. County staff also note that an entrance may be required for the retained agricultural lands and advise that any future entrance location, including a field entrance, will need 175 meter clear sight distance and 100 meter separation from the existing entrance on the severed lands. County planning and ecology staff had no concerns. And the Saugeen Valley Conservation Authority, Enbridge Gas, Hydro One, and Historic Saugeen Métis had no concerns with the proposed. So the proposed surplus farm lot will have about 0.9 hectares lot area with existing mature trees along the north side, fronting onto Gray Road 9. Contains no active farmlands. It has a single detached dwelling and a detached garage. The retained parcel is about 40 hectares with 344 meters frontage along Gray Road 9 and contains active farmland as well. The surplus farm dwelling is also within 250 meters of nearby barns, but MDS does not apply as there is no existing livestock barn on the subject lands. But a rezoning is required as a condition, of course, of consent to recognize the lot area and the frontage for the severed lot and to prevent any residential use of the retained lot as well. So the rezoning will be evaluated separately following the public planning meeting this morning. Happy to take any questions.
Very good. Are there any? Barb, go ahead.
Thank you. I have no issue with this. I was just wondering if you mentioned the Grey County comments and the requirement, the potential requirement, they're going to need a farm entrance to the farm parcel. Are they with the frontage that currently exists and the fact that the surplus property was right in the middle, is there 150 meters from that entrance that would allow the achievement of that laneway? I'm wondering if John can do some of those measurements. I don't know how to do that on GIS mapping. I just wouldn't want to prohibit an entranceway. This is why it's advisable to put the farm parcel over to the corner of the property line, I guess.
Through you, it's for the retained farm parcel, and it would be that has about 344 meters frontage on Gray Road 9. So it would meet that.
Very good. I don't see any other hands up or questions, so I do see Quest Immobile. That would be the applicant. Is that is that you, Jenny?
It is. It's Genevieve.
Oh,
Yeah.
Genevieve. Oh, I was just looking at the actual report, so I will call you Genevieve. That sounds a lot nicer than Jenny. So go ahead with your report and anything that you may want to add to the conversation here.
Certainly. Thank you very much, Chair. Good morning, everyone. My name is Genevieve Scott. I think I've met probably everyone on the call today. I'm with Questa Planning Consultants. I'm going to keep my comments brief, but just go through things, an overview of the proposal. We were retained by RHP Farms Limited and Cedar Acre Farm Limited to assist in processing the subject consent application, as well as the associated zoning bylaw amendment, which will be heard later today. So both of these farming operations are owned, operated and owned by the Pallister family. So as Victoria has indicated, the subject lands are on concession 12, lot 26 in the former township of Egremont, fronting onto Gray Road 9. They're about 9 kilometers southwest of Dundalk, and this area of the township is dominated primarily by agricultural uses. The use on the site historically and as proposed to continue has been agricultural. And we are looking to sever the house and the garage as it's surplus to the needs of the Pallister family, who all reside elsewhere. Just the original barn that was part of the farmstead has actually been removed, so there won't be a barn either on the severed or the retained as part of this application. The retained parcel will maintain a minimum 100-acre lot size, and the severed parcel will be about 0.94 hectares in area. So this is a fairly typical surplus farm dwelling consent. It's permitted with provincial, county, and township policy. It helps the farmers who are looking to consolidate farmland, and it helps the township retain some of the rural housing stock in these rural areas of the township. The application meets the intent of these policies. And I've taken a look at the agency comments as well as the proposed conditions, and I have no concerns or comments. I reviewed the conditions, the Grey County comments in particular, with Mr. Pallister, who has no concerns with respect to the county requiring a bit of a road widening across the frontage of the property. And just to respond to Mrs. Dobreen, with respect to the frontage, there's about 127 meters on the one side, on the west side, that would remain, and about 220 on the other side. So we're good there. So I'm happy to answer any questions. Otherwise, thank you very much.
Are there any questions for Genevieve? Brian, go ahead.
Thank you, Mr. Chair. Genevieve, I believe you mentioned that this is in the former township of Egremont. I'm pretty sure this is in the former township of Croton, is it not?
Yeah.
Oh, I beg your pardon. Sorry.
I just wanted to clarify that to make sure we were in the right township. So
My apologies.
all good. No, that's fine. Thank you.
Well, the former Proton, a beautiful spot now, Southgate.
Yes, my
Now
apologies.
Southgate. Yeah. Good catch though, Brian. Good catch. Any questions for Genevieve? Seeing none, there is a part where we say if there's anyone in attendance, and I see an iPad 5. So if they want to speak for, that's fine. And that has gone off my screen. So anyone opposed to this? And I don't see anybody. I will again ask committee members if there's a requirement for further discussion, review. Seeing none, may I request a mover to grant, defer, or refuse this application. Brian, go ahead.
I'll move that we grant.
Okay, Barb, you had your hand up. Will you second that? Thank you very much. One thing, with the Gray Road wanting 2 meters, is that going to be in addition to all the recommendations, Holly, or that's just going to be something done? Ken? Go ahead.
Yes, through you, Mr. Chair. Sorry, actually, Holly, go ahead if you want to
Yeah.
go first.
Go ahead, Holly.
I don't think that it needs to have its own clause. We do have the standard conditions, which also include road widening to the satisfaction of the township or the county. So we will just ensure that that's done at the time.
Okay, well, thank you for that clarification. Ken, your hand's up again.
That's exactly where I was going. So
Great minds think alike, you two. Great minds think alike. So, with that being said, be resolved that staff report PL 2026-015 RHP Farms Limited, 186142 Gray Road 9, be received for information, and that this committee considers approval of consent file B1225 subject to the following conditions: that rezoning be in full force and effect, prohibiting future residential use of the retained lot, and address frontage area and any other deficiencies in the applicable zone for the severed lot, and that a reference plan of survey be provided to the satisfaction of the Secretary Treasurer, and that standard conditions apply as recommended by agencies, including that all requirements of the township, financial or otherwise, to the satisfaction of the Secretary Treasurer prior to issuance of a certificate of consent, including payment of any outstanding taxes, fees, and any other charges, if any. And the decision of this committee was to grant this application, and the applicant shall have 2 years in which the conditions must be met. So, Holly, I know. All in favor? Got it right that time. That's great. Thanks for your patience, guys. My mind goes off all over the place when I see so many people looking at me. So that's a blessing anyway. So the decision of the Committee of Adjustment is to grant this application. And the notice of decisions from today's meeting will be signed electronically by members and distributed accordingly per the Planning Act. The committee decisions may be appealed pursuant to Section 17D of the Planning Act within 20 days of the date of the notice to the OLT. And may I ask for a motion to adjourn? Brian, and then seconded by Jim. Okay, well, I guess we'll see as all in favor? There we go. And I guess we'll see you in a short time. So thank everybody.